Welcome back. Time is 8:14 here. We want to get to a story as we continue our coverage of Charlie Kirk's assassination and the fallout from that. Secretary of State Marco Rubio recently said visa revocations are underway for foreign visitors celebrating the assassination of Kirk. Kirk was fatally shot at an event on the campus of Utah Valley University last week. The conservative activist and Turning Point USA founder was a close ally of President Trump and other administration officials. Now, during an interview with Fox News on Monday, Rubio said that the State Department will not grant visas to those celebrating Kirk's death and will revoke visas from those doing so. We want to bring back in our chief legal analyst, Charlie Kirk. We've talked about the Secretary of State's position on different visa holders celebrating things like the war in Gaza and what they would do to people in that situation. First, let's start here. What's his legal authority to for visa holders that are currently in the United States? Not talking about approving them, but people here right now.
Well, approving current people that are residing here or people that are actually attempting to come in, it's within his discretion. So I'll start there. But the main question is when we're in court and we're trying to get evidence in, the court has to make a determination as if it's inadmissible or if it's admissible. That's the same question that they're asking. Our founders of our laws really weren't creative with looking for new ways for terminology. And so admissibility is the key factor. The State Department is going to make a determination, is this person admissible or are they inadmissible? And so that can fluctuate. You may have been admissible prior to coming into the country. They granted you a visa. And then at some point now you have been deemed to be inadmissible. Something has occurred. Specifically, if we're looking at social media posts, for instance, you've done something to support some terroristic organization historically in the past. That is what would have been sufficient for the court to be able to determine that now you're no longer admissible, and then they can go and start the process for revoking your visa. Not automatically going to start the deportation process. Normally what would occur is that your visa would be revoked. Then you'd have a deportation hearing, and at that hearing you'd be able to defend or prove and fight why you should not be removed because of the statements or the allegations that are against you. But to your original question, yes, 100% within the discretion of the Secretary of State to do that.
Okay, when we talk about supporting terrorist organizations, obviously everybody has condemned the assassination of Charlie Kirk. What freedom do visa holders have to not celebrate, but to have freedom of speech?
That's an excellent question, and this would be a law school type of question. If I was still teaching, I would love to use this example as a testing challenge to kids' ability or students' ability to be able to decipher the law and then apply it to a different set of facts. And so in this scenario, you raised the First Amendment question. Are there First Amendment protections for speech? I mean, yes, we know that you've given First Amendment rights for speech as a citizen. So then the deeper question is, does a person that holds a visa have First Amendment protections? And it's broken down into two places. Outside of the country, no protections for First Amendment. Once you're in the country, yes, there is case law to support a visa holder having First Amendment protections. So then you may ask, well, what are the protections and how may I be, shrouded in the same protections as you or I as an American citizen? Not as much, but there are protections. The standard is just lower. If it's a First Amendment argument and the State Department is saying that I'm going to limit this visa holder's ability to speak and I'm going to challenge their removal or their granting of a visa because of something they said, the standard of review is that they have to be able to point to, the government does, a facially legitimate and bona fide reason. That's all they have to say for why they're denying your entry or your keeping of a visa, connecting it to your speech. And so if it was you or I and they were saying, hey, I'm going to limit your speech, it's going to be a way higher standard, compelling public interest, narrowly tailored. It's going to be the highest standard, strict scrutiny. In this scenario, it's going to be basically floor level. And the courts have held continuously that we can limit a person's attempt to get a visa based on their speech, even if they have free speech protection.
Is there any argument if it's not applied fairly across the board? And I'll add to my question, say a visa holder celebrated the assassination of Melissa Hortman. Would they be then say, okay, well, you didn't deport this person or revoke their visa because they celebrated the assassination of a Democratic leader, but you're deporting somebody who's celebrating the assassination of Charlie Kirk? It needs to be fair.
That is an amazing question. Again, a law school 101. It normally, when you are attempting to limit, chill, or slow down a person's speech, it has to be content neutral. It has to be, I can't specifically say I didn't want the red wall, but I wanted the blue wall, so I'll exclude all the folks that like the red wall. Now you've targeted their specific speech. And so historically, the courts have said if it's going to be targeted towards not content neutral, then you will have a problem. But again, if they can get to that hurdle of facially legitimate reason, then it doesn't matter. One case I can cite to you is that there's this Mandel case, happened in the 70s. A professor wanted to come speak at an institution, and they didn't want to let him come speak because of things he had said in the past. Well, every case since then, they've used that Mandel standard. I've said before that speech isn't just what you say, isn't just what you wear, but it's also your ability and my ability to hear other people speak. So professors sued and said, hey, you're stopping this speaker from coming, and you're denying me, an American citizen, their First Amendment right to hear him. The courts went right back to Mandel and said, well, they don't have to do that high standard. It's the lowest standard. Right. And because of that, we can deny his ability.
Queen City News Plus. Just search Queen City News on your smart TV's app store.